Yeah. And the way I see it is they're using their one and only warrant and reset. So after that, what happens next, up to them. Oh, you're good. No, I just had her standing there. We were doing actually several other things, so. All right, you ready?
Yes, sir, I'm ready.
Okay. All right.
In your on this case, I have to put something on the record also. I spoke to Mr. Shepherd about it. So.
Okay, perfect. Because these are those cases that drive Marty and her team crazy. So,
Right. And this one is really a bad one.
okay. All right, well, let's do all that. All right, you ready, Kathy?
Yes, sir.
All right, is it Caslin?
Yes, it is.
All right, please raise your right hand for me. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take a step forward, grab that mic, lean into it, and state your full name for me. You'll move all around for you there.
Shalindra Caslin.
All right, Shalindra Caslin. Ms. Caslin, you're here on 23 SR 1494. Yes, so, which is multiple charges of mandatory education for children 6 to 16. What we're going to do is work our way through this plea here, and then Mr. Charles and I will discuss what the terms are, and then we'll go from there. You are on time for court today, is that correct?
That's correct.
Did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, I did.
Did you understand those rights?
Yes, I did.
Ms. Caslin, your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document?
I do.
Do you recognize it as the written version of those rights I read out earlier?
I do.
Are those your initials next to each of the lines on page 1?
It is.
Page 2?
It is.
And is that your signature?
Yes, it is.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, I did.
And that, did you have a chance to ask Mr. Charles any questions that you had?
I did.
And did you understand everything that's on this document?
I did.
Now, have you had all the time that you need to speak with Mr. Charles about all aspects of your case?
I did.
Are you satisfied with the job Mr. Charles has done on your behalf?
Yes, I am.
Do you understand that you have the right to a jury trial on your case?
Yes.
And that by entering this plea, there will be no trial. This case will be closed. Is that what you want to do?
Yes.
Okay. Ms. Caslin, do you have any questions for me about anything before I speak with your attorney?
No, I don't.
All right. Mr. Charles, do you stipulate, I'm just going to put to these 4 identical counts of mandatory education to a minor, which are counts 1, 2, 3, and 4 from 9/21/22 here in Spalding County.
Yes, I do.
And Ms. Caslin, do you wish to enter a guilty plea to 4 counts of mandatory education for a child 6 to 16 here in Spalding County?
Yes, I do.
All right. I find that between Mr. Charles's stipulations as to the 4 counts combined with Ms. Caslin's request to enter a guilty plea, that there's enough for me to take this plea. I find that Ms. Caslin is knowingly, voluntarily, and intelligently waiving her rights and entering this plea. I reviewed the recommendation and I will follow it. All right, Mr. Charles, let's talk terms here. Tell me what's going on with this case.
Your Honor, Ms. Carsten physically every day took the child to school, dropped the child at the front door. The child go to the school, don't go to class, go and sit in the gym. The school finally realized that, in fact, as of 2 weeks ago, she was still doing that.
Mm-hmm.
Dropped the child to school, went to work, the child take off.
Wow.
And Mr. Shepherd and I will discuss it. We said, what can we do? And the only thing the school does is call her every night. She's not in school. She's not in class. But she physically dropped the child to school.
That's not lost on me, ma'am. In fact, we were just discussing, we have an intern that started today, and I was going to introduce him to you, Mr. Charles, but I was telling him about these cases and how the most difficult ones are the ones in exactly the scenario that you just described.
And now the child is 16 years old, still doing the same thing. So basically,
Wait, the child is 16 now?
yes,
She 15. She'll be 15 on May 21st tomorrow.
When does she turn 16?
next year.
Okay.
She just going to be 15 tomorrow.
That's why we had to do at least 2 counts.
Yeah.
But it's a nightmare for any parent to physically drop it. You don't rely on the bus. She said because she knows she wasn't taking the bus, so she physically take her because she went to work and get a call that night. She wasn't in school.
So the child's on campus, just not
In class.
in class.
And I've met with the the school teachers and the ones that she have now, and came to a conclusion that it was something going on between her and the actual teacher. So they resolved that, had a sit down meeting, but it's still the result of what already occurred.
Okay. So this situation is unlikely to resolve itself with this plea.
Exactly. But see, the law is basically what it is. The child is not in school. Parents pay the consequences. But this one, she physically take the child to school. And math, which is her first period, she never went to math class. And now the school realized that. That's why they haven't charged her for the first few months, because they realized the child is in our campus, but she's not in class.
Mr. Shepard, all we're doing is discussing that when the child in these mandatory education classes is like 15 or so, it gets really difficult. We're just having a general conversation about it, just to bring you up to speed, that the mid-teenager drop-offs are tough. Well, I think this is a good balance, the sentence that y'all have come up with. Sentence enforcement, these are very difficult for sentence enforcement. They kind of wear our sentence enforcement folks out. But generally, that's with the younger folks. With the older folks, we're usually able to figure out some other options. So I'm just going to say, Ms. Caslin, I don't know if the school would give you any sort of credit for dropping your kid off. I honestly don't know if you could walk your kid to the front office and sign your kid in and then they see your kid. I don't know. I'm saying I don't know the solution, but if from the court's perspective, if you have taken your kid and relinquished control of your child to a school system team member, that satisfies the court's interest in this case. I'm interested in what you're doing. I am interested in what your kid's doing, but I'm more interested in what you're doing. So you need to figure out a system. And again, you got the summer. We have like 3 days left of school here. But you need to be in communication with the school of a system that lets you be able to tell sentence enforcement with some sort of school backup that you did your part. Does that make sense?
It makes sense.
Okay. And that's going to be your job to figure out. I'm not going to figure that out for you. But if you want to be able to say to sentence enforcement or to me, I did what I was supposed to do, I'm going to look at you and go, okay, prove it. Give me something from the school system that says you dropped your kid off each morning like you were supposed to. After that, if you don't have something like that, I'm probably going to shrug my shoulders. So you have the summer to figure that out. You get that? So you got 90 days to talk to the school and figure that out. But I'm telling you that if you get your kid to school and you can show me proof that you got your kid to school, you and I are going to be okay.
Okay.
Do you understand what I'm looking for from you? And you have the summer to figure that out, to speak with the school and figure out a system. I don't know what that looks like, and I'm sorry.
Okay. I mean, I don't. The only thing that they've given me was the attendance, and I have records. Half of the stuff that they gave me that they have her unexcused for don't even match up with the records that I have for what she's excused for. The days that they have unexcused, I have excuses for those days. So it's like they're recording days that's I already have excuses for.
I know. And that's a lot. This happens in all of these cases. There's tons of confusion. And so I'm trying to bring your situation to a very simple moment.
Okay.
I need you to get somebody at the school to sign off that you delivered your kid to school.
Gotcha.
That's all I need.
Gotcha.
You do that, we're good to go.
Okay.
Because it's up to the school to manage it from that moment forward, in my opinion.
Okay.
So I'm not saying that's the best plan. That's just the best simple plan I can come up with.
And I can already think the school system would say, we're not taking it for you to come and sign and sign at the front door that you signed in. The private school will do that, but the public school.
They don't.
No, and that's why I'm saying you got the summer to either come up with that system or try to find some similar system. Just go speak with them.
Okay. And I've been numerous of times. I'm a very active parent.
I can tell that you care, and so I'm just saying these cases wear us out, because then we have to get into, well, why was May 18th unexcused and why was May 19th excused? And frankly, I just want to come up with a system that lets us just check this box off and let you confidently know that you've done your part, and then we're done. So, and I don't know what that looks like, but you have the ability to make the parents that come after you a system that works a lot better for them than what you are coming into. Okay? All right, we're off record.
Okay.
Yes. Good to see you. You know, it's been Kathy's dream her whole career to go to Superior Court. I think we should put in.
Yeah, they do it, but definitely that's So this is the right now today.
Wow.
Let me go back right there. Let me think.
Yeah, but it's an arraignment, so then they're taking warrants and
I guess what I'm looking at, if it came to like
I got one fake count.
yeah, we already went from
trial,
So fascinated by this question.
when the deputy took a warrant,
Sorry, Kathy, your life on
it
there.
actually came from the school. So why does the school?
I'm just asking.
Because if I had to try it, I would have somebody from the school system here.
Okay, that answers my question.
I didn't get it.
I think I got totally sidetracked.
Just whatever you want to do. I don't.
Let's let her meet with sentence enforcement, and then, Margaret's walking back in my papers, which makes me think y'all are all on the same page of how I might be wrong. Are those unsigned? You need to sign. They're not. Oh, no, these are. Let's do this. Let's do this plea while she meets with them. The lady that we just did the mandatory education, I missed a part of sentencing, so she has to go back and see me. Yeah, but we'll meet with them, and then I'll go over. I don't know that I signed her papers either. So, that was Miss Caslin. So, yeah. So just don't let Miss Caslin leave. I need to put one more thing on the record for her. All right, you are Miss Wright.
Yes, sir.
Miss Wright, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay. Take your hand down and state your full name for me.
Aaliyah Marie Wright.
All right. And Miss Wright, you're here on 23 SR 1606, and you were on time for court today. Is that correct?
Yes, sir.
Did you hear the rights read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Miss Wright, you have passed up to me this self-represented defendant plea rights waiver. Do you recognize this document?
Yes, sir.
Do you recognize it as a written version of those rights I read out earlier?
Yes, sir.
Are these your initials next to each of the lines on page 1,
Yes, sir.
page 2,
Yes, sir.
and is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
And did you understand everything that's on it?
Yes.
All right. Ms. Wright, you have the right to a jury trial on your case. Do you understand that?
Yes, sir.
And that by entering this plea, there will be no trial and this case will be closed. Is that what you want to do?
Yes, sir.
Okay. Ms. Wright, you're charged with one count of affray and that you did have a physical altercation in a public place with an Atana Taylor on 9/24/23 here in Spalding County. Is that correct?
Yes, sir.
All right. I find that with your admission of guilt, there's enough for me to take your plea. I'm going to find that you're knowingly, voluntarily, and intelligently waiving your rights and entering this plea. I reviewed the recommendation and I'll follow it. Do you have any questions for me about anything before I sentence?
No, sir.
All right. Ms. Wright, on 23 SR 1606, count one, affray, guilty, 12 months, 590 is your fine. You may work off your fine with community service work. No alcohol, illegal drugs, or hemp products shall be tested for those. You'll waive any foundations for admissibility. Fourth Amendment waiver, $60 per month supervision fee, $50 intake fee. You may go to non-report once 3 months have passed, no violations have occurred, and all conditions have been met, which includes 20 hours of community service work and no contact with Taylor. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. Okay, do you have any questions for me about anything before we part ways?
No, sir.
Okay. All right, thank you very much. Clint's going to walk out those double doors.
Okay, thank you.
And today is clearly wear cool cartoon t-shirts to court day. So that was the Rick and Morty t-shirt.
I told her earlier.
Yeah. Well, and somebody had a Naruto t-shirt, which was my son's favorite show when he was in his teens, young teens. So, and then somebody else had a, oh man, what's the, not the Pikachu, the, whatever the show is. Pokemon. Had a Pokemon shirt on.
I'm embarrassed, I know.
Well, I was almost there. All right, you're Mr. Brown?
Yes, sir.
All right, Mr. Brown, please raise your right hand for me. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your hand down and state your full name for me.
Robert Danielle Brown.
Mr. Brown, you are here today on 23 SR 1491. You're a junior, is that correct?
Yes, sir.
Okay. And Mr. Brown, you, were you on time for court today?
No, sir.
You were one of my late people?
Yes, sir.
That's fine. It just tells me what questions to ask you.
Okay.
I'm holding up this self-represented defendant plea rights waiver. Do you recognize this document?
Yes, sir.
Do you recognize your initials next to each of the lines on page 1?
Yes, sir.
Page 2? All right. Are these your initials on page 2?
Yes, sir.
Is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
Did you understand everything that's on it?
Yes, sir.
Are there any questions I can answer for you about anything anywhere on this document?
No, sir.
All right, Mr. Brown, you have the right to have an attorney represent you, and you're here representing yourself. Is that what you want to do? Do
Yes, sir.
you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial. This case will be closed. Is that what you want to do?
Yes, sir.
Did you act in a disorderly manner in the presence of an Aaliyah Wright back on 8/6/22 here in Spalding County in a manner that threatened the immediate breach of the peace?
Yes, sir.
All right, I find that with your admission of guilt as to disorderly conduct, there's enough for me to take your plea. I find that you're knowingly, voluntarily, and intelligently waiving your rights and entering this plea. I reviewed the recommendation and I'll follow it. Any questions before I sentence?
No, sir.
All right, Mr. Brown, on 23 SR 1491, count 1, disorderly conduct, I'm gonna find you guilty. It's 12 months probation, 590 is your fine. All other charges will be dismissed.
All
That's a
right.
total of 12 months probation. No alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver, $60 per month supervision fee, $50 intake fee, 20 hours of community service work, and no contact whatsoever with Ms. Wright. You shall also have no contact with 731 West Taylor Street. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. Okay, I'm just going to pass those over to you, Margaret. All right, Ms. Yarborough is going to walk out those double doors.
All right.
That's fine. And I need to talk to Ms. Caslin too, so. All right,
Got the last one working now.
that's fine. And Ms. Caslin, I missed a piece of her sentencing. Ms. Caslin, the mandatory lady, I missed a piece of her sentencing, so I've got to put something on the record with her.
She'll be out as soon as she
Yeah.
finishes back here, she gonna come.
That sounds great. All right, we're back on record. Tell me how to pronounce your last name.
Upadhyay.
Do it again.
Upadhyay. Upadhyay. Yeah.
Upadhyay.
Yeah.
Upadhyay. Mr. Upadhyay, if you will please raise your right hand for me. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
All right, take your hand down. State your full name for me.
Yeah. Pranav Upadhyay.
Upadhyay. Mr. Upadhyay, you have two cases on the calendar today, 23 SR 1666 and 23 SR 1667. You, I believe, were late to court today. Is that correct?
Yeah. At 10 o'clock.
It's okay. It just tells me what question to ask you. Are these, I'm holding up this self-represented defendant plea rights waiver. Do you recognize this document?
Yeah.
Are these your initials next to each of the lines on page 1?
Yes.
Page 2?
Yes.
Is that your signature?
Yeah.
Did you sign and initial this document after having all the time that you needed to review it? And did you understand everything on this document?
Yeah.
Are there any questions I can answer for you, Mr. Upadhyay, about anything anywhere on this document?
Mm-hmm.
Do you have any questions?
No, I understand.
Okay. Mr. Upadhyay, did you see on this document where you have the right to have an attorney represent you?
Yes.
And you're here representing yourself. Is that what you want to do?
Yeah.
Do you understand that you have the right to a jury trial on both of your cases?
Okay. Yeah.
And that by entering this plea, there's going to be no trials
Okay.
and your cases will be closed. Do you want to close your cases with these pleas?
Yeah.
Okay. Mr. Upadhyay, starting with 23 SR 1666, count 1, theft by shoplifting, is that you did commit the offense of theft by shoplifting by taking merchandise from Ingalls on 10/20/22 here in Spalding County. Did you do that?
Yeah.
All right. And then count 2 is a public indecency charge on also at the Ingalls on 12/8/22, and that you did appear in a state of partial undress. Did you do that as well?
Yeah. I was drunk. Yeah.
Okay.
Yeah.
All right, then I find that with both of your admissions of guilt across both of your cases, that there's enough for me to take these pleas. I find that you are knowingly, voluntarily, and intelligently waiving your rights and entering these pleas. I reviewed the recommendation, and I'll follow them as you have negotiated. Can I answer any questions for you about anything before I sentence?
No, that's only, I already started the anger management. I finished that.
Oh, anger management, thank you.
Yeah. And I'm working on my alcoholism also. I already did the 3 classes. I have to finish the 12. So I already started that.
Excellent. So you've started your anger management, you're working on your sobriety.
Yeah.
Good for you. That's what we want to see here. So
Yeah.
thank you for that.
Thank you.
All right, then you ready for me to sentence? You ready for me to sentence you on these documents?
Yeah.
Okay.
Yeah.
The sentence of the court then, Mr. Upadhyay, is as follows. Starting with 23 SR 1666. Count 1, theft by shoplifting, guilty, 12 months, $870 is your fine. You may work your fines off on both cases with community service work. On both cases, you'll have no alcohol, illegal drugs, or hemp products. You'll be tested for those and you'll waive any foundations for admissibility. Fourth Amendment waiver, $60 per month supervision fee, $50 intake fee. And this first case, 1666, would be consecutive to any other sentence of this court. In this case, you'll have 20 hours of community service work and no less than 6 hours per week, and you are not to go anywhere near the Ingalls on Zebulon Road. All right, that closes out 1666. On 1667, count 1, public indecency, I find you guilty. It's 12 months probation, $870 is your fine. Same conditions, except this case is consecutive to 23 SR 1666 for a total of 24 months of probation. Same no contact, and an additional 20 hours of community service work. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights to challenge these convictions. All right, any questions for me about anything before we part ways?
No, sir. Thank
All
you.
right, thank you very much. Mr. Phillips can walk out there. Ms. Caslin, if you'll step back up to the podium.
So I'm sorry.
Ms. Caslin, through no fault of your own, I missed a piece of the sentencing that I needed to put on the record. So I just brought you back in so I could read a couple of things off of here onto the record. And that is not your fault. That is my fault. So Ms. Caslin, on count one, mandatory education, guilty, 12 months, 590. Count two, mandatory education, guilty, 12 months consecutive, 590. Count three, mandatory education, guilty, consecutive, 12 months consecutive, no fine. Count four, mandatory education, guilty, 12 months consecutive. That's a total of 48 months of probation. All other charges are dismissed. I've already given you your obligations to have no additional unexcused absences. I understand how difficult that will be for you. And so I'm saying spend the summer to see if there's another option that will protect you. If you're, as your child is older, if you had a third grader, I would have a different response. But you don't have a third grader, you have a 15-year-old. I live with a 16-year-old, so I just want you to know that my heart goes out to you. Teenagers are difficult on their best day. So sorry about missing that. Like I said, that was just the paperwork I forgot to read out loud. Do you have any questions for me?
Okay, so the probation is something that I have to report to?
So that is correct. But the goal is, frankly, the goal is to get your kid back in school. Like that's the goal. So go and do that. And then let's, we can circle back in a year or so and figure out where you're at. Because remember, you told me in a year from now, your kid's going to be 16. Is that your final child? Do you have children younger than 16?
Yes.
Okay.
9 and 7.
Okay. Do we have any issues with them getting to school? Okay. All right, look,
They always have been car riders. I always been, assisting them, taking them and picking them up.
and your 15-year-old turned 16 on what day?
May 21st. Her birthday actually tomorrow. She'll
Okay.
be 15.
Well, come back and see me in a year then. Let's have that conversation in a year. Okay? When your child turns 16.
Okay.
All right. Thank you so much.
I know. So with the suspension.